Yes, Mr. Mohammed, you may proceed.
Yes, thank you, Judge. I would like to begin by reading out a statement. This hearing is the matter of CFI 020-2020 before Her Excellency Justice Maha Mheiri and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Bird & Bird MEA LLP. Lead counsel is Stephen Thompson QC. The defendant is represented by Clifford Chance, Lead Counsel LLP. Lead counsel is Daniel Fletcher.
Okay, Mr. Stephen, you may proceed.
Good morning, my lady. My learned friend and I have our cameras on. I don't know whether we're doing this hearing as a video hearing or a telephone hearing, but I'm happy to do it either way, according to how your ladyship prefers.
It's fine. If you want it on or if you would like to close it, it's up to you. I don't mind.
Okay. Otherwise I'll feel like I'm the only one who's putting my camera on, so I'll turn it off so you don't think I'm vain. Lady, this is a case management conference of the case of Stormharbour Securities and Noor Bank, all we really are here to resolve is the timetable for and the timing of the trial of the dispute. But perhaps I can just a couple of minutes outlining the scope of the dispute, because it's clear that the parties have a slightly different reading of the pleadings. One would have thought that you could not really disagree with each other when it comes to working out what the dispute is from the pleaded cases, but unfortunately in the course of trying to determine the list of issues in the case summaries, it's evident there are some disagreements about what the case is actually about. I just want to spend 2 or 3 minutes just looking quickly at the particulars of claim and the defence. The particulars of claim is very short and starts at B4. It's only about 3 pages if you ignore the heading and the back sheet and the prayer. And you can see at B4, if your ladyship has that it's all about a deed governed by English law between the 2 parties. That gives you a flavour of it. It's really just about what the deed says. At least that's what the claimant, my client, says. I'm not going to ask you to read every paragraph of the particulars of claim, but if you look at paragraph 4 on page 5, it said that by the defendant agreed with the claimant to sell to a company to be incorporated and nominated by the claimant for this purpose. That's a Cayman Islands company, by a sale transaction, all those Shaheen certificates which it held under one of 2 alternative deals on terms set out in 2 draft. And just pausing there, so that was the point of the deed. There was going to be a sale, but it could have been on one of 2 alternative bases. We then say, the claimants say, that, and this is paragraph 8, that the defendant, which is a bank, pursued discussions with Etihad Airways and reached a settlement with it. That's nothing to do with the deed on its face, it was a separate deal. But paragraph 9, the effect of the settlement was that the defendant put a sale transaction on the terms set out in the term sheets out of its power. So that means one of the 2 deals was impossible after that. Then in paragraph 13, we go on to say that by clause 2.7.1 of the deed, which is the critical clause, the defendant agreed to pay a proportion of any cash consideration of the Etihad settlement received by the defendant at any time, from time to time, on each date it received the same, under a formula which then works out A, at about $6 million, and then B, up to another $6 million. And paragraph 14 is critical. We say that those sums by the bank to my client under clause 2.71, so that's the 12, nearly $13 million, were payable whether or not the sale transaction was consummated. So our reading of the deed is that that sum is payable if the is made, and there's no dispute that the Etihad settlement was made. So effectively what we claim is that money. You can see that from the end of the document. Now that's 5 numbered pages, but as I say, only really 3 if you discount the long prayer in the title. The defence, by contrast, which starts at B11, goes on for some 11 or 12 pages. Why? Well, because the defence, the bank says, firstly, the actual deal between the parties was repudiated. That's at paragraph 4 on page B12. So paragraph 4 says, as to paragraph 7, and then if you skip down to 2, to the contrary, the claimant proceeded to repudiate the deed. And then it says how that was done in some events in December, 2nd of December, in B, 17th and 20th of December, at C, 24th of December. So the defendant says the deed was repudiated. That's one genuine point of dispute between the parties. And they say if it's repudiated, then they don't have to pay. But they then say, and you need to pick this up at paragraph 13, B16, they then say, in any event, the deed needs to be rectified. It's ambitious to seek a rectification of a lengthy deed negotiated by commercial parties, particularly if you're a bank that you would have thought would have access to competent lawyers to the deed recorded the agreement. But nevertheless, I don't dispute that it's open to the bank to say the deed needs to be rectified. They'll have to persuade the judge at trial that the deed didn't accurately record the parties' agreement. So from paragraphs 13 through to 28, that is to say a good half, if not more, of this document, you have a detailed pleading saying how and why the deed ought to be rectified in the minds of the defendant. And so they say, for example, at paragraph 17, that new words should be added in. The words, and if the sale transaction is consummated, should have been followed by words to the effect, on terms that other certificates are included. And similarly, in paragraph, so then you then have a paragraph 21 and following pleadings about what the parties communicated to each other by email before the deed was made. The deed was made on the 2nd of December 2019. So the defence goes in to talk about what happened in November 2019. So by the nature of a rectification claim, the defence will open up all the negotiations and then consider what the parties meant. And if you look at paragraph 28, it's clear that's what they want to do. They say 28, if therefore contrary to paragraph 12.5 above, the true and proper construction of the deed is that the defendant is obliged to share with the claimants the proceeds of the settlement with Etihad Airways that was agreed in a legally binding settlement outside the standstill period, which is our case, that's the claimant's case. Then the defendant says the above continuing common intention was not reflected in the deed, there was a common mistake and the deed should be rectified. And you can see at B22 of the bundle, there's a seeking that rectification, effectively bringing into play all those paragraphs 13 to 29 that deal with rectification. So that would suggest to you that the nature of the case or the issues in the case are: one, did the claimant repudiate the deed? Two, does the deed fall to be rectified? The process of rectification can be quite a tortuous one, because the court has to investigate what the parties intended at the time, what they said, what was being drafted and passed backwards and forwards, what's being said on phone calls, and so fine. That's what the defendant wants to say to extract itself from what we say is otherwise a clear obligation to pay this money. But if that's the defence, then they're obviously entitled to run it. We have broad agreement on how long it will take to determine it. I think said 5 days, the defendant said 6. That's because there's some additional third witness which the defendant says is unable to identify that it might want to call. We have identified 2 individuals who will be giving evidence. The defendant has identified 2 but says there might be a third without naming that third. we don't quibble with it being 6 days if that really is how long it needs. The real dispute between the parties is when the trial takes place. This claim was issued in February. The claimants obviously have an expectation and entitlement that the court deals with the dispute expeditiously as possible. The registry has made it clear in emails to us over the summer in June that the expectation of the registry is that trial should come on for determination within 6 months of the CMC. It's now the end of September. 6 months from now is the end of March. That might be, we accept a quick timetable, but it should be one that people should aspire to meet in order to ensure that disputes are resolved quickly, as of course they always should be by the courts. The defendants say, and I'll leave Mr. Fletcher to expand on this, but what they say is they haven't got the lawyers available for that. They say they can get everything ready by about April, but then they want to wait until September next year, 12 months from now, before they actually have a trial. That however nice it is for the court to accommodate the convenience of individual barristers and solicitors and lawyers, the primary consideration ought to be the speedy resolution of disputes, and that should be done as quickly as A, the court can accommodate, and B, the parties can reasonably prepare their case. So that's the first area. When should a trial take place? The timetable for when everything should happen in the lead up to a trial, there's not a lot of dispute between the parties. If you see Mr. Fletcher's skeleton argument that he's produced for this hearing, I think he set out a table showing the different dates, and I know Bird and Bird have lodged a document that identifies the difference as well. There's not a huge dispute. Once your ladyship has determined when the trial should take place, I suspect the directions won't be too difficult to resolve. Suffice it to say that really the complicated bits will be those bits where the defendant says we need to trawl through what happened before the deed was signed. Normally you don't have to do this, but in a rectification claim you do, and so there will be an element of exploration. Nevertheless, the time period is pretty short compared to most bits of litigation. We're talking about only November and December 2019, and not very long ago, less than 2 years. Many cases that your ladyship will have seen go back many more years than that, and the investigation involves looking at a longer time period than that. So we say really the parties should be encouraged to press on with resolving this dispute, and not, as we half suspect, just slowing matters down for the convenience of one party or indeed its lawyers. So those are the main disputes. There's a small dispute about whether skeletons exchanged or dealt with sequentially. I'll just touch upon that briefly. We say in a case where, as you can see, the biggest area of dispute is whether the deed should be rectified, that it makes sense to have the skeleton arguments exchanged. Everyone can see what each other person says. In fact, there's something to be said in this case for the defendant going first, because it's their own arguments on rectification which they want to rely on, and they've put forward for the first time in their defence. Nevertheless, we will settle for exchange if that is going to be convenient for the defendant. Obviously, there is a default rule in the RDC saying that the claimant goes first, but that's subject to what the court thinks is appropriate. And we would submit that in a case like this, it's appropriate to just have the parties exchange their skeleton arguments 4 clear days before the start of the trial. It's going to be a relatively heavy trial. 4 clear days, we think, is probably appropriate. So I think those are all the areas of dispute. I haven't touched upon the disagreements between the parties on the list of issues because it's not really a matter for the court to resolve. But suffice it to say, the list of issues finally agreed because we don't agree with the defendant about what the case is about. The defendant has insisted on removing from the list of issues those rectification sections that I took you to, and has included some other paragraphs, or wants to include some other paragraphs, that deal with what was happening with the claimants' lenders behind the scenes, which is not a pleaded issue, as you can see from the pleadings. Anyway, as I say, those probably aren't matters for today, given that the list of issues is but for 3 sections effectively agreed, and so I hope it's going to be a satisfactory level to a stage to go forward from the CMC. So unless there's anything else that I can address at this stage, that's all I needed to say on the timetable of how matters should progress down to trial, my lady. Thank you.
Thank you, Mr. Stephen. Mr. Daniel? Mr. Daniel?
Hi, yes, can you hear me now?
Yes.
Pardon. I want to start by just identifying some matters of common ground so that your ladyship is aware of what needs to be determined and what does not. I will start with the list of issues, and just to say that we, the defendant, agree that there is not an issue for the court to resolve there today. And so it isn't necessary to decide whether certain paragraphs should be or should not be in the list of issues. We agree with the claimant in that respect. I want next to deal with the timetable between here and the trial. One key point to bear in mind, my lady, is that the parties have agreed that it is the registry to set the trial date some weeks in the future, rather than yourself today. You can see that in the draft order. If I take you, for example, to the claimant's version in the bundle at page A3, there is paragraph 18. And it states that by 4 p.m. on the 11th of October 2021, the parties must agree with the registrar a fixed date for trial with an estimated duration of 6 days, plus 1.5 days of judicial pre-reading. And there is the same paragraph in the claimant's draft order. So in that respect, the task of setting the fixed date is also one that's not necessarily before your ladyship today. It is one for the registrar in 2 weeks when the parties go to the registry with their mutual availability. And I think that is notable because the claimant has said nothing about its availability for trial in the months of May, June, July, despite those, it seems to be months in which it's alluding there should be a trial. So I just want to clarify that as well for you. What that means is that there are only 2 areas for your ladyship to determine today, and those are the timetable for witness statements and the progress for document production, witness statements, and the progress monitoring date. And then, as my learned friend said, the skeleton argument point as well. Did your ladyship have time to read the case memorandum and the list of issues before this hearing?
Yes, I read it.
Thank you. And as you'll have seen from those, this is we say a complex and a high value case that involves numerous factual disputes. I think Mr. Thompson described some of the factual matters as torturous, going through the drafting history of the parties' deed, events in November and December 2019, the parties' subjective intentions when they entered into the deed, and then as well in factual dispute are the contents of various phone calls and meetings between the parties in November and December 2019. Now, what all of those factual disputes emphasize is that there is going to need to be a thorough investigation of the documentary records that were created by the parties' dealings. And it's therefore critical for the procedural timetable to provide each party with enough time to produce and to request relevant documents, and then to prepare witness statements that address the many areas of factual dispute, and in particular, phone calls, and meetings. Now, to give the parties a fair amount of time, I have set out each party has set out a proposed timetable, and as Mr. Thompson said, there is a summary of that in paragraph 9 of my skeleton argument. It may help to have that to hand so that you can see where the timetables diverge.
Yes, I have it.
Thank you. There are 4 issues causing the parties' timetables to diverge, such that there becomes, by the end of the proposed timetables, a 4-week difference. The first of those is the first item in the table, which is the date for standard production. Now, the defendant has proposed 4 weeks rather than 3, and that week is necessary for my instructing solicitors to finish reviewing several thousand emails and documents for potential production. And from what I've heard from Mr. Thompson, there's no suggestion that it can necessarily be done any quicker. He himself recognized that if the defendant is going to open up the drafting history, then there are many documents that will need to be reviewed. And we say for that reason that it is necessary for this additional week to be provided. There is then a point of divergence on the amount of time for objections to requests to produce documents. Now, we have said 3 weeks, whereas the claimant has said 2. The additional week is necessary because on the proposed timetables, this period of time will fall over a large public holiday in the UAE. So there's a 3-day public holiday, I understand, between the 30th of November and the 2nd of December. That will effectively remove 1 week from the timetable. And so in order to ensure that there is a good amount of time, which would perhaps ordinarily be 2 weeks, there needs to be a 3rd week to account for the loss of the week for public holidays. So that is why we say there should be an additional week at that step. Then the 3rd step at which the parties' timetables diverge is the amount of time for the court to rule on the disputed requests. And here, the defendant's position is that because on its timetable the period is going to fall over the New Year period, we say it is wise for the court to allow itself 3 weeks for those determinations, because some staff will be away simply for New Year. Some judges may be unavailable because of Christmas and because of New Year. And essentially, the court should reserve to itself an amount of time that it will need when its resources may be thinner than usual. And so we say that's why a 3rd week is appropriate at that stage. And then the final point at which the timetables diverge is the amount of time for reply witness statements. Now, the claimant has proposed 2 weeks. We say 3 weeks. The reason is this. The claimant's witness statements are very likely to have to set out the contents of phone calls and of meetings that are likely to be disputed. Now, some of that evidence may be foreshadowed by documents in production, but by and large, that evidence will come in the claimant's witness statements. And now, we say that 2 of the defendant's witnesses are busy senior employees, and they are going to require more time than just 2 weeks to review the claimant's witness statements and to prepare their own reply ones. Of course, it's necessary that they review the claimant's statements in detail and are thorough in their preparation of reply statements, because that will assist the judge at trial. It will ensure that the parties are engaging with each other's evidence and that the defendant's witnesses are addressing what are likely to be disputed accounts of those meetings and calls by the claimant. So in my submission, it is important that there is adequate time there, ultimately to assist the trial judge at trial. Now, together, those 4 weeks will push the timetable out a little bit, but in my submission, they will not prejudice the claimant I say that for two reasons. The first is that the claimant has sought interest on its monetary claim, and that interest will compensate the claimant for any delay to any judgment that it might obtain. So whilst, yes, in another case where there might not be interest or there was some urgency to seeking relief, there might be a need for a rushed trial. Here we say there's no need to rush this case towards a trial when the claimant will be compensated with interest in any event. The second point is that the 4 weeks in the timetable will not actually delay the trial date. And that is because prior commitments of the defendant's witnesses and its legal representatives will prevent them from attending a trial before the 19th of September 2022. Now, the claimant has said it wants the month of April, but of course April is also Ramadan. Then from May 2022, my leader, Ms. Camilla Bingham, QC, who will be conducting the trial, she has prior commitments with a trial that run to at least the end of June 2022. Then in July 22, there are prior commitments among other members of the team. August, as we know, is the holiday season for much of the legal sector. And then once everyone is back in September, the team will need time to prepare for trial. Hence, the earliest date that we've suggested is the 19th of September 2022. I would, of course, remind you that I'm not saying the trial date should be set today. As I stated at the top, the parties have agreed that the trial date is to be determined by the registry in due course once the parties have been to the registry with the mutual availability. And so in that sense, what is critical to note is that the additional weeks for the timetable will not push back the trial date, because the trial date is going to be pushed back regardless. Now, in its note and then in submissions, the claimant suggested that the trial should be held within 6 months from the date of the CMC. It was described as an expectation of the registry. Of course, there is no rule to that effect. There's no rule requiring proceedings to be rushed to a trial simply to meet an ideal of 6 months. By contrast, rules 1.6 and 1.7 require the court to give effect to the overriding objective of dealing with cases justly. And in this case, I say there's nothing just about rushing the case to an early trial. If the claimant were to win a trial, then, as I've already noted, any delay will be remedied with interest. But by contrast, there is no remedy for the prejudice that the defendant will face if it has to rush its document production, rush the preparation of its witnesses, or otherwise rush its preparations to trial. Ultimately, it will assist the trial judge in navigating this case if the case is better prepared, if there are fewer gaps in the disclosure, and if the witness statements properly address the many factual issues. And accordingly, in my submission, the fair and the just timetable is one that includes the 4 additional weeks I have been outlining. In any event, the claimant's own suggestion of a trial in April is optimistic. I say that because the progress monitoring date that it suggests is late March, and the order then provides for a pre-trial review 4 to 8 weeks before trial. So unless those two things were to occur essentially simultaneously, that is the progress monitoring date and the pre-trial review, then an April trial is not going to be possible. Of course, that would leave no room for slippage in the timetable, and in my submission there should be a buffer period because of the complexity of this case and what is the likely inevitability of some slippage. Final point I'll just make on timetabling is that the claimant has not pursued its claim in these proceedings with any haste. Mr. Thompson noted that the claimant began these proceedings in 2021, in February, but that was not the beginning of this dispute. Actually, the dispute began in February of the year before, when the parties exchanged pre-action correspondence, but then the matter was largely left, and the claimant waited another 12 months before it issued these proceedings in February 2021. And so this suggestion that the defendant is the one delaying matters is wrong. It is the claimant who waited 12 months to even begin these proceedings, and it can't now ask for the court to rush a fair and just determination of this case simply because it wants to put pressure on the defendant. So for all of those reasons, my lady asked that there be these 4 additional weeks in the procedural timetable. They won't cause the claimant any prejudice and in fact will ensure that the case is best prepared for the trial judge. That brings me then to skeleton arguments. The claimant has suggested that there's an exchange and we've asked for them to be filed sequentially. In this regard, the defendant is adopting the default rule under the rules. That's rule 35.62A. Now, in his submissions, Mr. Thompson suggested that rectification is going to be the big issue and therefore it justifies an exchange of skeletons. But we say that ignores a raft of other issues, including an issue very much on which the claimant bears the burden of proof, which is the issue of interpretation. As Mr. Thompson alluded to when he took you through the defence, there is, before one gets to the issue of rectification, a prior issue of the proper interpretation of the document. And so it's not correct for rectification to be presented as if it is the be-all and end-all in this case. In any event, whether it's exchange or sequential is not about which party is alleging a larger set of facts or a more substantial claim. The purpose of having sequential skeletons is to assist the trial judge. It is to have the defendant's skeleton identify areas of common ground after reviewing the claimant's skeleton, particularly on the law, and then to address any new points that are newly raised by the claimant. Now, in that way, the trial judge can begin the trial with a clearer understanding of what they need to decide. That is why the rules provide for sequential service as the default, and we say the same reasoning applies with equal force here. If the claimant goes first, the defendant will be able to identify areas of common ground, particularly on the law, and to address any points that are newly raised by the claimant. In that way, the trial judge will be in the best position to have a clear understanding of what they need to decide at trial. And for that reason, we say skeletons should be sequential rather than exchanged. I think I've addressed all the topics that are on the table, but if you'd like any additional submissions on topics, please just let me know. Thank you.
Thank you, Mr. Daniel. I heard enough. If anyone wants to add anything before we conclude, you will receive my directions through the registry.
Might I, this is Mr. Thompson here, my lady, might I just respond on a couple of points that Mr. Fletcher made about timing?
Sure.
Just, I think it's just 2 things. Firstly, my learned friend Mr. Fletcher referred to the overriding objective, which is of course Rule 1.6, and suggested to you that the overriding objective is to enable the court to deal with cases justly. That's obviously true, but dealing with a case justly, Rule 1.6 includes 4, ensuring it is dealt with expeditiously. And it really shouldn't need to bear repeating that one of the principles of justice is to resolve disputes not just fairly but also expeditiously. Famously, justice delayed is justice denied, as it is often said. The error I suggest in Mr. Fletcher's submissions is to suggest that this is all a rush, and he said that a lot of times, and that his client needs or requires an awful lot of time to do many things, and that the claimant won't be prejudiced by that. That isn't really the test. Apart from Mr. Fletcher saying his client needs all this time, it's hard to understand why it is a very well-resourced bank in the region will need to take so very long to pull together a collection of documents produced over a period of 2 months. The question really is how expeditiously can the case fairly be resolved, and for that we submit the defendant has done nothing to explain why it needs, as it puts it, or requires, or it's necessary to have all these additional weeks to do matters. We accept there are holidays. Everyone has to cater for holidays in their business life. You simply do things a little bit earlier or later if you have a holiday. There's no great magic in a holiday. They don't take anyone by surprise. So the question isn't, is this a rush or is there a prejudice caused to the claimant? The question is, how quickly can the case be brought to trial? The only other point I wanted to make was on the lawyer's availability and the idea of setting a trial date. I mean, as you will know, my lady, the registry's standard email includes the line, the parties are kindly requested to ensure that the trial is listed to be held within 6 months from the date of the CMC. That, as I mentioned, was something the registry emailed out to the parties on the 22nd of June, but it's a standard email. Now, what the defendant needs to do when it receives that, even if it doesn't know that that is the rule, is to make sure that it sources a legal team that is able to accommodate the requirements of the registry. What you've been told by Mr. Fletcher is some of his team, including his leader, are very busy in the summer next year. Well, congratulations to them, but that should not be a problem that's laid at the court's door or at the claimant's door. The defendant needs to source lawyers that can progress its defence expeditiously and fairly, because it cannot be said that it is fair for a claimant to have to wait an additional few months for a trial simply because the defendant's preferred lawyers are busy. For those reasons, I do invite you at least to direct or encourage the registry to set down a trial, if not on a particular date, then in a window, to make sure that as soon as this case is ready to be resolved, it is set down for trial and the parties are heard. It's nothing to the point how long the claimant might have taken to issue its claim. The court is concerned with resolving disputes once those disputes are raised before it by a claim form. So for those reasons, even if you don't in your directions set down a particular date, I would encourage you at least to indicate to the registry that when the parties do attend upon it to agree a date, that they have no doubt about when it is that the court expects this trial to be heard. Thank you, my lady. I don't think I have anything further to add.
Thank you.
Unless I can.
Does the defendant want to add anything?
Just one moment, please.
Okay.
Thank you. I think I addressed many of those points already in my submission, so I'll leave it there.
Okay. Thank you both for your time. You will receive directions from the registry. Thank you.
Thank you, my lady.
Thank you, Mheiri.
Thank you.